intellectual property webinar. We have our longtime volunteer, David Sanker, supporting our work today, and he's going to be available to kind of answer a lot of questions that have come in through the registrations and through the chat, and just kind of give a good overview on intellectual property. My name is Anna. I am the one of the program coordinators at the Economic Justice Team for the Lawyers Committee for Civil Rights. Our work supports serving Bay Area small businesses that are low to moderate income, and we provide our program provides free legal consultations on liability issues, terms of commercial lease, business contracts, employment law, intellectual property, and other types of business concerns. I will send some information via chat so we don't take up too much time, but this is really a pretty informal space to just kind of chat with David and ask some questions about intellectual property, get a good sense of what intellectual property is and how to really understand it from the small business perspective. So we're yeah. David, do you want to go ahead and introduce yourself?
Okay, great. I'll do that. Yeah. So my name is David Sanker, and I've been working with LCCR for at least 10 years. It's been a very long time. So it's a very good organization. Enjoy working with them. Originally it's mostly in person and in downtown Oakland, where you would meet for the clinic, but and that went really well. But now with COVID, then we had virtual, and having webinars like this virtually can work really well. So we can reach more people. So this is a good opportunity as well. So my background, I've been working as a patent attorney for since 2007, so that's a long time. But most of my personal work is in patents, but also work with people on with copyrights, trademarks, and trade secrets. And so we'll talk a little bit about all of those. And actually, before I started work as a patent attorney, I was a software developer for 12 years, and prior to that, I actually taught math at the Holy Names College, which in Oakland, which unfortunately I had to close down recently. But anyway, so that's a little bit of my background. And I thought, so like Anna said, this will be really informal. I've given them a slightly more formal presentation on these topics a few times, and after the presentation today, I'll give Anna a copy of a slide presentation I've used in the past, so that you can all have that. But it should be more informal, just like let's just have a discussion. So before we get into this, some of the specific questions, I just wanted to give a little background in terms of the 4 areas of intellectual property law. Because it's useful to think about, okay, what area am I going to cover? Is it, which one is it? And so let's just start with one that most people are familiar with, is just copyrights. And so copyrights are pretty simple, and they're the quick info sheet that I hope Anna has sent to you all has information. It's like you can go to copyright.gov and register a copyright for anything. You just have you've got a PDF or other drawing format. You can file for a copyright, and there's very simple requirements for copyright. It's got to be something that is new, that you've created yourself, and it's got to be in a tangible form. That's all it's required. So a copyright, we think of books, but it can also be works of art or even statuary. There was one time at the clinic I met a person who created his own statuary work, and so yeah, that's something you can get copyrights on as well. So it's 3D art is certainly you can get copyrights on. And then there's trademarks, and trademarks are basically small things of words or pseudo words or symbols And the important part about a trademark is that the trademark is helping customers correlate a name with a goods or services that you're providing. So that's what the goal of a trademark is. And of course, the biggest one people always think about is like Coca-Cola. So you know that if you buy something that says Coca-Cola, you know what it represents. It's provided by the company, and that's so that's what it represents. The third one is patents, and I do lots of work in patents. So patents are for something that you actually invented something functional that's new and useful. Patents are very complicated and require a substantial amount of work to prepare a patent application and work with a patent office to get something allowed. So it's a very long process, and it's something that if you need patents, you got to be aware of the cost of that. Patents are substantially more expensive than other forms of intellectual property protection. And then the last one on the list, which I don't know if I've had any clinic folks actually have trade secrets, but it's important to know about. And a trade secret, unlike all the rest, it's like all it is like if something is valuable to your business, keep it secret. And if you can keep it secret, then it can be protected as a trade secret, so that if somebody misappropriates your confidential information, then you can sue them. And the most common case with that is where you have an employee who then leaves and then says, "Oh, I'm going to use that information to start my own company," and so they take information which could be it could be an invention, it could be just confidential information, it could be a client list, it could be any sort of valuable business information. But so if you have something that you need to keep as a trade secret, the important part is you've got to keep it secret, both physically as well as just not telling too many people, because if it's like everybody in your company knows about it, then it's probably not a trade secret. So everything within intellectual property has got to fit into one of those four categories. It's copyrights, trademarks, patents, or trade secrets. And so it's useful to have that framework in mind when you say, okay, so am I going to protect something? What way can I protect it? And those are the four ways. So that's the introduction. And now let's go. So Anna sent me some questions, but I don't know if you want to just ask questions right now. That's maybe that might work too.
Oh yeah, I actually had a question, David, to kind of like help me frame some of that information that you sent.
Right.
So I think so let's say I'm a author of children's books, and it's like a children's series. So I first want to start with one book, and I'm writing and then I want to write more eventually, but like this, I only have one. So I think then I would want to do copywriting, correct?
Absolutely. Copyright is the right choice for that. And while we're on the subject of copyright, so you may have heard that you sort of get a copyright automatically just by writing it down. And so it's sort of true, except that if you ever need to enforce your rights for a copyright against somebody else, then you actually have to have it registered at that time. And so in a sense, that automatic protection is really not much of any protection. And so if you need a copyright, file for a copyright registration in the United States at copyright.gov. Because it's not expensive, and unlike patents, which go through an examination process, and you got to persuade the examiner to give it to a copyright, you submit it, you get a registration number, and that's it. And so it's very, very simple, and it's not very expensive. I think the prices may have gone up, but it's around $50 to file for a copyright registration. And if you have multiple works, you can actually submit more than one at one time. You can't just submit 50, but you can submit up to 10 works under one copyright registration.
Got it. And then like, let's say the series, the kids book series has like a specific character or something like that, or like it's like maybe like a company like logo, like I'm like starting a company right now that I have a series. So then I would move into trademarking the logo. Is that correct?
Yeah, if it's something that's a logo, so like let's suppose there's particularly like a like if there's a very prominent character in a children's book, then it could be very a representative of the series itself, in which case you could file for a trademark for that character and say, yeah, this character represents, it represents these books. I'm using it to represent these books. And so actually one children's series that I know about is like there's the Cat in the Hat beginner book series, and on the front one of them there's this logo showing the cat in the hat with his hat, and it's like, okay, so they've got that logo, so you know that if you see that, that's part of that series. So that is something that you could get a trademark on, and that's a good example, because that's not a word. We think of trademarks as being words, or at least sets of lists of characters. Letters of the alphabet. But it doesn't have to be. It can be a symbol, or a symbol together with some letters. Something like that is a trademark. And so yeah, when you want to have something that's identifying the source of it, and just like in the case of a book series, like the source is the author. It's like this is my series, or in the case of like the Cat in the Hat beginner books, it's the publisher, represents theirs, so they would use a trademark for that.
Got it. Thanks, David. I think we do have some questions coming in. I think there's one about trademarking the business name, and if there's similarity in terms of like another business name.
Yes, and so it's very useful to think about when you file for a trademark registration, it is examined, and because you want to make sure that it doesn't conflict with another similar mark. And so there's two issues to think about. One is, how similar is it to another mark? And so there's some like if somebody had just trivial example, like let's suppose that I say, oh well, I'll add an S to Coca-Cola and I'll make it Coca-Colas. That's not enough to have a distinct name. That's not going to do it. So the key test for trademarks is whether is the likelihood of confusion. Is an ordinary consumer likely to be confused by seeing one mark versus somebody else's mark? And of course that's that's not a bright line rule. You'd like a really clear rule, but it's kind of hard. It's like, how do you say? But that's the way it's like. You think about, would an ordinary person be confused by this? Is there a reasonable chance that a person would be confused by it? If so, you're not going to be able to get the mark. The second thing though is that when you apply for a trademark is in a specific class. So when you have to think, oh, what's my class? So for example, the company that used to be called Apple Computer, which is now Apple, somebody could get a trademark for the name Apple in the context of computers, while somebody else could have get a trademark for Apple, say in the context of if I had a machine part that was somehow called an Apple or something. It's like so if something is in completely different areas, the same name could actually be used, because it's like, well, as long as there would be no confusion to the to people about that, well, these products are for in this area for one person and another area for a different company. So when you're looking at this, you want to look at both the likelihood of confusion of just the name itself, but also in terms of what's the classification, what's the area that you're trying to cover. Sometimes like with folks that are coming to the LSE clinics through LCCR, I've worked with enough of these so that I can give you a pretty good idea of whether is that unique enough or not, and it may. So if you're using just very descriptive terms, it's pretty hard to get a trademark on something. So if I say fuel efficient car, and I'm going to try to trademark that, it's like, well, that's just completely descriptive. There's nothing. I'm not going to be able to get a trademark on that. Whereas if I come up with my own name that nobody's ever heard of before, I could get a trademark on that.
Got it. And I think we do have a really interesting question via the chat, and I'm just going to read off what it says. And I think some might apply to like maybe a deeper discussion in one of our virtual legal clinics, but I think it would be really interesting for you to weigh in on this since we're on this topic. So it says, hello, we registered our business name in 2014. We do not have a trademark on our name. Recently, we've seen another brand via their Instagram account. I'm not sure if they are a registered business themselves, using our business name as the name of a pop-up they are hosting. Our guests thought it was us, but it is not. Is there anything we can do without a trademark?
So the thing to do is, as long as you can prove your earlier use, then you can file for a trademark now. So unlike other areas where you have to, like copyrights or patents, you need to file those right away. A trademark, there's no rule that says when you have to do it. As long as you can prove that you started this in 2014, and that's earlier than somebody else, then what I would recommend is file for a trademark now. And once you've got that trademark, then you can send a cease and desist letter to that other company that's using it. You could send a cease and desist letter right now, but without a registered trademark to back it up, they'd probably just ignore you. So the thing would be to file for a trademark. The quick info sheet has it, so you could file for a trademark application for, it's around $225 or $250 dollars, and it's so once you file, a trademark examiner will look at it within, say, 4 months, and then assuming that they find that you've satisfied everything, you can get that issued relatively soon. So the process might still, the whole process might be, if you started it today, it could be as much as a year, but might be a little bit less. But I would definitely do that, and make sure that you have, if you do that, make sure that you have the definitive proof of your first use in commerce, because that's critical. If you don't have definitive proof of use in commerce, then it's kind of a problem. So that's important. How long does a trademark last? I see that coming up. Yes. So one of the great things about a trademark is that it can last indefinitely. So for example, Coca-Cola still has a trademark on Coca-Cola and will have it forever. So it can last indefinitely. The only requirement is that every 10 years you have to pay a renewal fee. So it's unlike patents where you have 20 years and you're done. A trademark can last forever. You pay the renewal fee every 10 years.
We do have a question about patent. We have a couple questions about patents.
Okay.
So we do have one via the Q&A that says, what should a software program be protected with a, when should a software program be protected with a patent instead of a typical copyright? And then
Yes,
some more general questions around patents and restrictions.
okay. So that's a really good question because if you have some software code, you can file a copyright registration for that. But as long, and you can file for a copyright registration regardless of whether the code is actually considered inventive enough, from a patenting standpoint. On the other hand, copyright protections are relatively weak in the sense that a copyright protection only protects the specific expression of the code that you use. So just as a kind of a trivial example, let's suppose that you've got a software developer who writes a program in Python, and they've got this program working just great. And then somebody else sees that and says, hey, that looks pretty good. That's a pretty good design. I'm going to rewrite this. I'm going to use those general concepts, but I'm going to write it in Java. If they do that, there's no copyright infringement. You didn't copy the code. You just learned from the code and got the concepts, and so you're able to rewrite it in another language. So if you want to protect the actual something that's inventive, then you actually need a patent, because if your software code was protecting some really creative, interesting algorithm, you could file for a patent protection on that, and then it doesn't matter what a person does if they're using that same algorithm that you've got a patent on, then they're infringing regardless of what particular words they use in what particular programming language. It doesn't matter. If you've got a patent, it's a much stronger protection because you're now protecting the ideas, the fundamental algorithm, the inventive aspect of it. But of course, whereas a copyright registration, you can file with the Copyright Office, and it costs you $50 or so. Whereas a patent application, it might cost initially about $12,000 to have a patent attorney draft the application for you to get it filed. And that's not it, because then you got to continue to work with the patent office to get it allowed, which might cost at least that much more. And then you got to pay the issue fees. And so, I mean, it would not be unreasonable to expect that it might cost you $30,000 to actually get a patent issued. So it's great protection, but it's a lot more expensive. There are some times when you can get assistance through LCCR to get a law firm to be able to do some of this work on a pro bono basis. But I don't want to guarantee that can always happen. But there are some cases when you can get assistance. A few years ago, my law firm just said, I'm not permitted to do patent work on a pro bono basis. They just arbitrarily made this rule, and so I can't do it. But I know that some law firms can. So ultimately, you can get both copyrights or trademarks. Copyrights are relatively weak. Patents are very strong, but patents are much more expensive, both in terms of cost as well as time. You file a copyright registration today, and it's like, you get it pretty much immediately. Filing for a patent application, like, you could start the process. It takes a few minutes to get drafted. Then you file it. You wait a year and a half before the patent examiner even looks at it, and then it takes more time from there. So it's figure it's at least 3 years before you get anything issued. 3 years and $30,000 before you get something issued. So it's expensive. So it's sometimes very hard for a startup company to be able to afford what it costs to get a patent. On the other hand, if you've got some really core technology that really represents what your work is, then it's worth doing. And if you need some assistance, then check with Anna and see about if we can get you matched up with somebody to actually help out with that.
Yeah, we do have some limited support for intellectual property cases as well. I am going to go ahead and unmute somebody that's wanting to answer or ask their question live. So Leslie, I'm gonna go ahead and unmute you now.
Hello, hi Leslie.
Hi there. How are you doing?
Great.
Good. I have a question. I am in the patent process and almost to the final stage. I'm glad to hear you say 3 years because I'm ready to tear my hair out. We're at that final end of the provisional stage. COVID put them back like 6 months. They kept telling me, you know, I'm in touch with my examiner regularly. And then now they're catching up. So now I finally made it to spot number 10. And he says, these things can kind of come in and get in before you if they're like did something before you and they're higher priority and I'll have to take them. And so I'm finally at that point. And one of the things he brought up to me in our last chat is he said, it's an algorithm. It's actually a technology algorithm. And he said, it's looking good, but I might have some restrictions for you. And so I said, well, that doesn't sound good.
Yeah.
He said, no, he said, you know, he said it may just be, you know, someone who is in the patent space told me, well, it may just be that it may not just be that they're going to throw it out entirely, that maybe they're going to say you can use it only in this context. So I wanted to know, like, what are your thoughts about restrictions when all of a sudden you're told and you're getting near the finish line? Is that something that like could make and break our strategy where we'd have to turn the company on a dime and say, okay, we're not going to focus in this sector anymore. We got to focus over there.
So this is a good, the word restrictions is is not necessarily, so we got to be careful on it. It's pretty common. So like I said, after you file a patent application, you have to work with the patent examiner. And one of the things the patent examiner could say, well, see, here's these other patents that are doing exactly the same thing, therefore you can't get a patent. And so it's very normal while working with the patent examiners to amend your patent claims to say, oh, okay, well, I can't get coverage as broad as I want, so I'll have to limit the claims in some way. And I think that's what your patent attorney is telling you about restrictions. I think it's saying, yeah, that we're amending the claims to make them slightly narrower. So that's normal. The main thing is to be careful that they don't make the claims too narrow. Because I actually, like a few years ago, I met a person that they had a patent and their patent attorney had told them they had a really great patent. And so the person I met was wanting to sell the patent, and I looked at it and they didn't want to hear the fact that I told them, it's like, you know, that is so limited, it's not actually worth very much. And they didn't want to hear that, but so they got angry at me. But the point is, it's like, if you're narrowing just slightly, that's okay.
Exactly.
But sometimes your patent attorney may say, oh, well, it'll be easier if we just, you know, really, really narrow it. And so I would recommend looking at what they're proposing and making sure it's not too narrow. Because that's a big deal, and without seeing the specifics, I don't know whether what they're proposing is very reasonable or way too narrow.
Yeah, he hasn't proposed yet. So all I heard from him was that a possible restriction. And my question was also, because we're operating in 3 different classes, is if he came at me and said, wait a second, okay, you're in these 3 classes, and all of a sudden now through this restriction, you can only play in 1. And you can only use your algorithm. So let's say he says, so one of our areas is in the employee area, and that's one class. And then we have another class that's like loyalty and customer loyalty stuff. That's another class. So if he says, you know, you can only have this one, then what that means for us is we got to turn on a dime, shift our whole strategy, say, okay, we're going to take out this part, that part, and that part, because now we only can operate on this particular area because he restricted us from the other two. And then the other question on the heels of that is if we can get back the restricted areas. So if we go out the one, and then he either thought that, you know, this examiner either thought somebody else had it, or all of a sudden it's available to us again. So all of this, I'm sure
Yeah.
you're smiling.
Okay.
I'm sure, but I'm like in a quandary of muck, and you're smiling because you
Yeah.
know what.
I know what you're talking. Okay, so your patent attorney is actually using the term restriction requirement in the technically precise way, which is so there are some times when, okay, let's back up a second. So a given patent is only supposed to be able to cover one invention. And so sometimes a patent examiner will say, hey, it looks like you're trying to claim 2 or 3 or 10 inventions, and you can't do that all in one application. And so you're going to have to select one of those inventions to pursue. And so that comes in the form of a restriction that says, okay, the examiner says, here's the ones that you've got to select one of those. And it sounds like that's what you've got. And so that just means, okay, I can select one. But the important follow-up, which is that, yes, you are able to pursue those others. So and pursue those others in a separate patent application. And that would be what's called a divisional application. So you can say, okay, I'll file a divisional application and I'll pursue those other classes. And those other ones will still have the same priority date. So whatever your filing date was that you have right now, you will have the same priority date for these other divisional applications. So, I mean, it's more money because you have to file additional applications for these other divisional applications, but you're able to pursue it. So it's not like you're abandoning anything. You have the rights to pursue those other ones. And you don't have to file the divisional application immediately. As long as you file a divisional application at any time before the first one issues. And so my recommendation would be, choose whichever one of these 3 classes is the biggest one for you right now. Pursue that one. After it's allowed and it's about to issue, file a divisional application to go for one of the other ones. I mean, and if you had lots of cash, you just file the divisional applications now. I mean, there's nothing, you don't have to wait, but usually if cash flow is a problem, then it's like, okay, wait until the first one issues and then go for the other ones.
Thanks, David. Yeah, I think, Leslie, if you have any other questions, I think we'd love to see you at our legal clinic, and see if we can, maybe David can help us out.
We talk more. Yes, absolutely. Yeah. I'd love to see the details of your case. That would be great.
Yeah, thanks. I do have a question that I think was sent through the registration that I think might be really interesting to talk about. So this is talking about protecting artwork designed by somebody else for your business. So I guess the person is wanting to use artwork that somebody else designed for their business, and they're going to sell those designs on merchandise, and they don't want to get sued. And so kind of like what approach would you take, or what do you think that person should consider?
Right. So I want to make sure that we got the all of this question set up correctly, because the way it's written, the question written is like it was designed by somebody else. As long as that other person designed it for you, and that you have a contract that says so, and specifically you want to make sure that it's referred to as a work made for hire, then everything is fine. It's like if they can create this. They made it for you, and they've assigned their rights to you, and so you have the rights to it as long as it fits that they designed it for you. There's a contract that says that, and it says that the work made for hire. Then you're fine. Now, on the other hand, if it's just like if you just go scouring the internet and you say, oh, this looks really neat, I'm going to put that on a T-shirt. Then that's a problem, because it's like, whoever owns the copyright to that could sue you. So I'm guessing that this is a case where you have paid somebody else to design for you. And if you're paying somebody else to design for you, it could either be that you have a good idea of what you want. It's like, oh yeah, I want an image that represents a bear that's holding its cub or something, and I want them to be brown bears and this background or something. You could do that, or you could just say, hey designer, I know that you're really good, make me some good designs that I want to use in this way. Either one of those is fine, as long as the contract says that they are creating for you and that you've designated as a work made for hire. So if there's any follow-up on that, I want to make sure if there's a follow-up question, I'll make sure I address it.
I'm not sure if the person that asked that question is on oh, it looks like there's somebody that wants to, maybe this person was the one that asked. So I'm gonna unmute Luis Quiroz. Go ahead, Luis.
Hi, Anna. Hi, David. Yeah, that was my question. And it's precisely the situation you first stated, right? It is work made for hire. However, there was never any contract. So it was a verbal, like, hey, will you design these? I'll pay you X amount. Great. But now I'm running into the issue that I can't get in touch with the artist to now sign that it was work for hire. And I still want to sell this merch, but
Okay.
I'm stuck with there's no communication anymore, and I don't want to get into legal trouble if she sees her work that she received payment for from me. However, if she sees the work and then has an issue because there was no contract signed.
Right. So verbal contracts can be enforceable. It's a little harder. So what you would want is if you have for example, even an email conversation or a conversation on text that you have on a device that you have this and shows this. As long as you've got something tangible that makes it clear that there is essentially a meetings of the minds that says, yes, this person is doing work for you, then you should be fine. If there's nothing tangible whatsoever and it's just your word against hers, then it's tougher. The fact that if you have made a payment and hopefully have a clear record of that payment, and that she has accepted the payment, that's also pretty good evidence that this is a work made for hire. Of course, the details of the work made for hire may not be as clear. Just fact accepting a payment doesn't necessarily say that she agreed that it was a work made for hire. So the more evidence that you have in whatever form you have, in whatever communication, the better off you are. If it's not completely clear, then it's kind of a question of, well, it's like how valuable is this one a piece of work to you?
Yeah.
I mean, and if you want to be exceedingly cautious, it would be to say, forego this one and take this as a learning experience that anytime you do this in the future, you've got a signed contract before you do anything.
Definitely.
So, but yeah, so it's a question of like if you have enough, in writing in any form of email or text message or something, yeah. But if you don't have that, it's kind of particularly you just don't want to get into legal battles. Legal battles can get expensive, and so I personally I don't like litigation. It's like it can be very expensive and distracting from getting real work done. So.
And David, just a quick follow-up to that. So the work made for hire contract, would that imply the copyright is now the who purchased the work, or is there a separate thing that needs to be made for like a copyright?
Right. So in basically so you would still want to file for a copyright registration. So with the U.S. Copyright Office. And when you make that copyright registration, there's a place in the process where you indicate that it was a work made for hire, and you say, yes, this was created for me, and you could. I don't remember whether you actually submit the document, but you certainly you point that out when you file the copyright
The
registration,
application.
so
Okay.
that they know that. So it's on record that you've specified who created it. So you specify who the author was, but that they assign the rights to you as part of a work made for hire.
Got it. Thank you.
Thanks for that question, Luis. Yeah, I think we do have some other questions on the list. So from the registrations, it looks like someone so I'm looking at the last one, David. We want to introduce 2 projects. One, an innovative way to support homeless people, and 2, a way to help people minimize mental health issues. While we're in the development phase, we need team members to assist and want to protect shared ideas.
Okay, yeah. So so there's two things. First of all, it would be if these team members are say employees of an organization, then that's one thing that's probably fine. If they're consultants or other individuals that are kind of working on their own, then you would want to get non-disclosure agreements to make sure that they just say, yeah, they're not going to disclose. If there's any particular important concept, to say, yeah, this would be could be covered under the non-disclosure. And it's pretty easy to find a language for a non-disclosure agreement. One good source of you can find language online, but one particularly good place is like Nolo Press has good examples of some sample non-disclosure agreements, and that can be helpful also to protect against if somebody who's working on this and then decides to leave. You want to make sure that they're not allowed to disclose that to others. So, and then the last question here says, we hope to protect the shared ideas. And the question is, it's like protect. The question is, what do we? Or is it just protecting it from being? Yeah, I need to understand what the concept is of what's being protected. Is it because it may be, for shared ideas, it's probably not going to be protectable under patents or copyrights or trademarks. So this may very well be the one where the best sort of protection is trade secrets. And the other advantage of a trade secret here is you don't have to worry about, say, a patent examiner deciding that whether something is protectable or not. As long as it's valuable to you, you can protect it as a trade secret. And if you've got employees, it's useful for them to have some sort of an agreement in place that says that these things represent trade secrets of the organization, and basically you can't go use that elsewhere. And actually, as whether employee or a contractor, you probably want to indicate that these whatever identify specifically what you're trying to protect in terms of those ideas. Identify those as trade secrets, and point out that they can't that people can't share those with others. So I think that's probably the best way to go here is actually use trade secret protection. And since we haven't talked as much about that, it's like, what do you do when you want to protect something as a trade secret? And really there's two things. There's sort of physical protection. So if you've got, like, let's suppose you had some master plans that are written up in some binders someplace, then you want to make sure you keep that protected. Like if it's in a locked cabinet or something when not in use, or if you've got something, let's say an electronic copy of it, make sure that it's not just available to absolutely everyone. make sure that you identify the limits as to who has access to it. Because when you're protecting something as a trade secret, you got to be thinking of what happens if I need to enforce my rights. And if you need to enforce your rights, that usually means that, say, somebody else who's working with you leaves and goes someplace else. And so if you have to enforce those rights, you're going to have to go to a court, and you'd better be able to tell the judge that, yes, I took reasonable precautions to prevent this, but this person stole this idea anyway and is trying to use it. So you need to persuade the judge that you did a reasonable job of protecting it. And if you do a reasonable job, then the court will will side with you in terms of protecting it. But if you're not taking very good care of your trade secret, then it's hard. It's going to be hard to persuade a judge to enforce your rights that you didn't protect well enough yourself. So I think that's probably the main here. So protect it as a trade secret, and make sure that everybody that's involved in this is under a non-disclosure, so that they're legally obligated not to tell others about it.
Thanks, David. Did you have any additions in terms of, like, for what you've been hearing from folks in the questions, or like the folks that you wanted to kind of highlight?
Yeah, let's see. Well, let's start. Let's see how much time we have left. We have about 10 minutes left. So one of the things that I've found is it's like in terms of my work with the clinic, the biggest issue is always related to trademarks. And so I think it might be worthwhile talking just a little bit more about trademarks, because there are some times when people have a name that they want to use, but trying to identify, well, is that something I'm actually going to be able to trademark or not, is an important question, because it's like, you don't want to spend the money or actually already start your business, start using a logo, and then discover later that you can't actually use it. So it's useful to think about, well, what are some things that make something more likely to be usable as a trademark? And so a couple of things are, if it's just simple descriptive words and nothing else, it's going to be tough to get a trademark on that. And so it's useful if you have say a set of letters, alphabetical letters that say that doesn't actually even represent a known word, but it's something that you have come up with, and of course make it something that actually sounds pretty easy to remember is good. And so a few years ago, I worked with somebody who was creating new handbags and said, "Oh, I want to use I give a name, and I think I'm trying to remember the name, but it only had 4 letters in it, but it was a unique combination of letters, and it was easy to pronounce, and she got the trademark on it." And so that's something that we think about. So rather than descriptive words, something that's more unique that you've just made up. And one other issue is this is useful to know about trademarks, is that you've probably seen both the circle R, so like and also, so circle R, and the other one it's different, but it sounds like the same thing. It's a superscript with a TM. And both of those can be used to identify trademark protection, but they're quite different. So a circle R means that you have a registered trademark. And so you can't use that symbol until you've gotten official approval from the trademark office. So as soon as the trademark office says, yes, you've got the trademark, then you can use the Circle S. On the other hand, the TM has no requirement like that. And so you can use TM as soon as you say, yeah, I'm going to use this, I'm going to use this word as a trademark. Then you can just put the TM on there, and it's just a announcement to the world that I'm using this as a trademark. And that can actually be helpful because it's also, if you've got a proof of when you started using that, it's like, yeah, I started using this TM, and I'm making it clear that I intending to use this as a trademark. So the TM you can use as soon as you want to. It's like if you're already using a logo today, you could put TM on it and use it right now. But the Circle R requires an actual registered mark.
Thanks, David. We do have a question in the Q&A, and I can read it. It says, I have a friend that is looking to start his own business. He built a software architecture that organizes and monitors in-house software applications for his employer. He is hoping to use a similar architecture to build out his own portfolio of software programs. Without going into the facts of the case, how similar can these software architectures be without infringing on his employer's trade secrets, copyrights, or possible patents? Can it be argued that the architecture is a result of his own personal style of software engineering?
Yeah, and so it's, without seeing the details, it could be hard to say. So let's suppose that and it's also a question of whether that architecture is sufficiently novel to be considered patentable, and then of course whether the employer actually filed a patent application on it at all too. I mean, you know, if they filed a patent application on it, that's you know, that makes it tougher to use that. You really can't have a copyright for an architecture because a copyright is just a specific expression of code. So an architecture is really more of a you know, a functional thing. So I would say that you couldn't get a copyright on that architecture, and it wouldn't be a trademark either. So there's a chance that there's a patent on it, maybe not. And then the question is, well, is it you know, is it a trade secret of the employer? And in many cases, an employer or a company that's hiring a contractor is going to say that, well, whatever you created, I own. And that's pretty normal. Employers want that. They don't want to have people creating things and then having the people retain rights to those things themselves. So usually employers have gotten very good at writing up contract language that makes sure that they own whatever rights to things. So it's likely that whatever rights they are, the employer, it would belong to the employer. And of course, it's, if I was looking at the specifics, you know, I could change my mind because you know, different people might use the word architecture differently. Because like if the word architecture is being used to more just identify, say, a style of writing code, you know, that's not really protectable. So like I personally, I mean, I did software development for 12 years. I have a very unique style of writing code. But you know, if somebody wanted to copy my style, they could. But it's also the company I was working for couldn't prevent me from continuing to use my style. So it depends upon whether the word architecture really means sort of kind of a more functional structure, or is it really just stylistic? So depending upon that, if it's more structural and functional. If it's functional, then it's probably any rights to that would be owned by the company, and you really shouldn't copy it. But if it's more just stylistic, then you know you can't prevent people from using their own style.
Thanks, David. That was really helpful. And I think a really good suggestion would be to ask your friend if they want to attend our virtual legal clinic. We can
Sure.
we can really support more with more details and have a one-on-one consultation with one of our pro bono attorneys.
Yeah.
And my colleague Nicole sent that information via chat. Any other additions, David, that you think that you wanted to share out?
I think that's pretty good, and I'm gonna send you a copy of the, this presentation that I had used earlier, and I'm just gonna, I'm gonna email that to you right now, so,
Yeah, and while David is emailing and sending us that resource, I will be sending a recording of this webinar to everyone that has registered, and also we'll be sending the resource that David, as well as information about the legal clinics that we have, and the document that I sent at the beginning of the webinar. If you have any other questions, please feel free to send to our LSC email, which I think Nicole has also sent via chat. If not, I will send it shortly. Anything else, David? Or if anybody else has another question that they actually want to ask right now, you can raise your hand.
okay, so I just sent that presentation. So the presentation has, you know, a little bit more about all four of the things we talked about, you know, trademarks, trade secrets, copyrights, and patents. So it was, I mean, a reasonable general discussion. I mean, I liked our informal format here, but you know, if you want to have something to refer to, the formal presentation could be useful.
Yeah, definitely. Any resource I think is really helpful. Thank you, David, for helping us answer some questions today. I think if anybody else has any additional questions, you can go ahead and register for our free virtual legal clinic. Yeah, Nicole sent that registration. And then if you have any direct questions to our team, we also have our LSE email in the chat. Thanks to Nicole. But yeah, thank you again, David. I think this was so wonderful. I learned a lot. I think
good.
it was really great to have a little
Good.
bit more of an informal discussion. Yeah, and thank you so much. We're going to go ahead and end the webinar and send you all the recording.
Great. Thank you, Anna.
Thank
Thank you
you.
all.
Bye.